attorneys summarize arguments against Nebraska's successful medical cannabis ballot initiative. Attorneys summarize their arguments this week for why a district court judge should void the election results last week for Nebraska's successful medical cannabis ballot measures. On November 5th, Nebraskans overwhelmingly voted to legalize and regulate medical cannabis. On November 5th, Nebraskans overwhelmingly voted to legalize and regulate medical cannabis. Though a legal challenge continues in the Lancaster County District Court. The lawsuit, filed by John Kuhn, a former state senator and former member of the State Board of Health, seeks to invalidate those measures, citing allegations of systemic fraud and malfeasance that permeated the process. Kuhn sued the 3 ballot sponsors of Nebraskans for medical marijuana, as well as Nebraska's Secretary of State Bob Evnen, who certified the measure for the ballot. Since then, Evnen, through the Nebraska Attorney General's office, has joined Kuhn in arguing that tens of thousands of petition signatures were tainted by circulator fraud or notarial malfeasance. The campaign needed 86,499 valid signatures on each petition for ballot access, which Evnen said the campaign reached on September 13th, although he cautioned that a civil investigation continued into the petition effort. The main arguments from Kuhn and Evnen allege that cheating is a choice and that the instances of fraud or malfeasance should eliminate the presumption that other signatures a circulator or notary touched are validly collected. Think about that. That's crazy. The court cannot turn a blind eye to the sponsors and Nebraskans for medical marijuana campaign members' willful disregard of the Nebraskan Constitution and the statutory schemes that regulates the initiative process, the AG's office wrote in a Tuesday brief on behalf of Evnen. Kuhn's attorneys have endorsed and similarly advanced Evnen's argument that notaries regularly and willfully did not notarize circulators' petition pages while in the presence of one another. Self-notarized petitions they circulated or notarized without a circulator's oath present. Notarizations add worth to a signature on a piece of paper, Evnen's attorneys added, alleging that the pervasiveness of fraud makes it practically impossible to distinguish genuine signatures. Intentional wrongful conduct permeated the campaign from top to bottom, the AG's office brief states. Their abuse of the public trust, their willful disregard of the law, their willingness to let the ends justify the means have brought us here. If District Judge Susan Strong accepts these arguments, she could allow the ballot sponsors to try to rehabilitate signatures and prove their validity. Can you imagine what it would take to prove the validity of over 86,000 signatures beyond what's already been done? Evnen's attorneys argue that that would be futile. Strong could also rule against or for the sponsors outright and end the trial. No matter the outcome, Judge Strong and the attorneys involved in the case have signaled the ruling would likely be appealed to the Nebraska Supreme Court. The core of the legal arguments advanced by Evnen's attorneys hinge on the 1919 Nebraska Supreme Court case dealing with an anti-women's suffrage referendum that allowed all signatures tied to a circulator who had committed fraud to be tossed from the ballot, defeating the anti-suffrage effort. What a fantastic pedigree for these fuckers. The 1992 Nebraska Attorney General's Office opinion, which doesn't carry the same weight as the judicial ruling, suggested the same standard should be applied to notaries. And that was a misprint by the article. It's not 1992, it's 1919. Evnen's attorneys point to both the 1919 ruling and the opinion and nod to other states that have tossed election measures or results because of wrongdoing or fraud. Kuhn's original lawsuit was broader, including allegations of irregularities in voters' printed names, birthdays, addresses, or other information, which Evnen denied. Strong allowed that claim to move forward, as well as a cross-claim from Evnen, but dismissed Kuhn's other allegations. When the trial began, Kuhn's attorneys instead focused on the notaries and joined Evnen's argument. They said in filings Tuesday that the ballot sponsors had no interest in the rules and that when someone's credibility is questioned, that can be extended to other actions. It is the individual's credibility that is impeached, and all acts by that person can be determined to have lost credibility, Kuhn's attorneys wrote. The ballot sponsors' attorneys accused Evans and Kuhn during the trial of focusing on notaries specifically because they couldn't find a path to invalidation, so they ignored past precedents. The sponsors' attorneys have said no court in the nation, to their knowledge, has ruled that notarial malfeasance can be extended to all documents. They've said that would affect any unrelated documents such as wills, purchase agreements, or other legal documents that a notary has witnessed. Even worse, Nebraska's highest election officials advances a burden-shifting framework that threatens to undermine and eliminate the initiative's right altogether, the sponsors' brief states. The ballot sponsors were given until Friday to file their post-trial brief. The opposing attorney can offer a response if needed by Monday. The AG's office said if the signatures are allowed to stand, that could undermine the people's faith in the precious power of the initiative or send a message that cheating is allowed so long as enough can be concealed or covered up behind the guise of potentially valid signatures. Throughout a 4-day trial, the state's attorneys narrowed in on Krista Eggers, a ballot sponsor and the campaign manager for the measure. They showed texts where she told campaign volunteers to push the limits or ignore the rules, which the AG's office said included the law. There is no more nice campaign, Eggers said in one text to a top campaign volunteer. We don't follow the rules anymore, and we just pay the consequences and hope it's okay. The attorneys for the ballot sponsors have alleged that Eggers' texts are being taken out of context and didn't show what the AG's office alleged. Among the witnesses for Evnen were two paid circulators, Michael Egbert of York and Jennifer Henning of Omaha, who said they violated the law. Egbert pleaded guilty last week to a Class 1 misdemeanor of attempting to commit a Class 4 felony of falsely swearing a circulator's oath. He admitted to using a phone book to forge voter signatures. Egbert was a notary for 6 petition pages for Egbert. Miss Eggers had no memory of notarizing Egbert's petitions and states these documents were notarized by mistake, likely because they were inadvertently mixed with a stack of petitions from circulators that properly showed Mrs. Eggers her ID and signed in front of her. The ballot attorneys wrote on Eggers' behalf an illegal filing. Hennings has not been charged with a crime. She alleged that Eggers told her to pick up petitioner pages from Seward County, sign the oath of a petitioner she didn't circulate, and drop them off at Eggers' house to notarize later. The ballot sponsors, attorneys, have moved to impeach Henning's testimony, citing that she is on probation for 2 counts of felony insurance fraud and has submitted fraudulent documents to Nebraska courts in the past decade. Henning offered text to corroborate her testimony and said she is on medication to help her mental health, which she has said has led to bad behavior.
Oh, boy.
Other evidence presented at the trial includes expert testimony from Mark Songer, a forensic document examiner from Colorado, who reviewed 150 circulator signatures from 5 people at the request of the AG's office. Songer said his review suggested possible forgeries on signatures from 3 of the 5 circulators, though he later confirmed he didn't review each circulator's signatures and was doing so in a condensed timeline. The AG's office brief states that the office was unsuccessful in locating all 3 circulators with alleged forgeries to confirm whether they signed and circulated the suspected petitions. In closing, the Initiative Measure 437, the legalization petition, passed with 71% voter support. Initiative 438, the regulatory petition, passed slightly behind with 67% of voter support. Citing a Nebraska Supreme Court case in 1905, the AG's office said an election is allowed to be rightfully squashed if the process is so infused with fraud, corruption, or gross irregularity that lawful voters can't be determined. Mind you, that means that they're saying more than 21% of the votes that were received had to have been fraudulent in order for this vote to have not been more than 51%. But I digress. The appropriate remedy is declaring the results of the election void, the AG's office said. Nebraska's state constitutional officers will meet December 2nd to certify the election, and legal arguments can continue after that date. Okay, this was a mouthful. I thought about condensing this article, but too much of it is too good and worth listening to. So let's talk about what happens in a representative democracy when people don't get their way and they go to the courts after the fact to try to kick up dust. We've seen this Mr. Kuhn guy has been fighting against this since day one, and apparently he doesn't know when to throw in the towel. This is Yarrow Kubrin, High at 9 News. I'd like to hear what the rest of my pundits think and feel about this today.
Fair enough. I feel by the time this whole thing is all said and done, we'll have a whole sequel to Belly, Yarrow.
I mean, I'd like to see, once again, as we always say, the will of the people actually represented and actually, honored. But I think it's unfortunate that some of these arguments, while they're not fully valid, are pretty strong arguments, right? Like, it sucks that there was so much malfeasance that happened during this process that he was able to find these things to keep picking at. You know what I mean? So, like, maybe if we would have not inadvertently, oops, I didn't know, certified some results, we wouldn't have these issues to pick at. But hopefully Nebraska will win in the end, because it's not looking so great.
Yeah, and like, who would have ever thought there would be so much action going on in Nebraska, of all places?
Certainly not the Cornhuskers fans.
Yeah, but I will say that the advocates that were the petition gatherers did kind of set themselves up for these types of challenges by not having enough wherewithal to really make sure that they were doing everything in the correct way, because they knew that there would be a ton of scrutiny against all of their actions in regards within a state like Nebraska. So I wish they would have been a little bit smarter with it, so that way they could have avoided a lot of these legal challenges. But I think ultimately, they're going to be they will be successful in initiating this voter initiative.
So we've seen petition signature gatherers here in California, and they tend to be temporary day workers frolicking in the Safeway parking lot and asking people if they're willing to sign something. So I wouldn't say
and they get paid by signature, Yarrow. They get paid by signature. They're not paid on an hourly rate. They're paid based off how many signatures that they obtain.
I just wouldn't say that that's a highly skilled workforce to begin with. And then we have to ask ourselves the question, well, if you need more than 86,000, what's the percentage that might, with a non-highly skilled workforce, might do something that's not proper? Is that 1%? Is that 2%? Is it always 0%? The thing that I think is most concerning is the extension of this argument that because a little bit or some or maybe a teeny smudge was done improperly, that the entire thing should be invalidated. If we extend that logic, that means that anybody who did anything improper, anything they've ever notarized, is now invalidated. And I think that's a dangerous precedent to try to apply, when I think that when we look at the percentage of voters who approve these initiatives, even if there was some dealing from the bottom of the card deck, the chances that they could have tipped the scales so much above the required threshold for these things to win is, I would say, incredibly low at best.
I think it's concerning that they're going to allow legal arguments to extend after the election's even certified in December. Like, at some point, you have to stop and say, hey, guess what? We didn't want this to pass. It did. We lost. Let's suck it up and start figuring out how to regulate this in a way that's going to be meaningful.
Yeah, I'm with you, Jenny. They need to suck it up.
Suck it up. I mean, there's a reason why you have to do a cleanse before a colonoscopy, right? If you know that somebody's going to give you a full inspection, you make sure that your shit's clean. That's all I'm saying.
Oh, man. Jesse, you have any thoughts on this? You're on mute, Jess.
It sounds a lot like what happened in Montana. I mean, Montana legalized a medical bill in 2004, and then the state legislature was not happy with the people at all, and it went toe-to-toe into 2011, and there was a huge fight, and it took the people everything that we could to overcome what the Senate was trying to do, because they reversed the decision in 2011 for a while, and it was a huge fight to get it back. So it sounds like Nebraska is in for a fight.
Yeah, no, they definitely are in for a fight, and the good news though is it doesn't sound like it doesn't sound like what happened in South Dakota is going to play out in Nebraska, because we all know that the will of the people, the initiative passed initially in South Dakota 2 years ago, and then Governor Kristi Noem said, "Nah, we're not instituting that. That is not happening. Throw this back. This is not gonna fly over here."
Yeah.
What troubles me is that the person who is really putting up the biggest fight here is a former lawmaker. We can imagine or surmise that he's not down to his last dollar, and he's using resources to jam up the system in order to continue to further his agenda, which was clear from prior to the election. And so the idea that they're going to cry foul and then use that to invalidate the will of the people, it's not a new playbook, but it's concerning to me. It's also concerning to me because if they're successful in doing that, it's something that might be applied in other states that haven't bolted on a medical or adult use program yet.
Yep, fair enough. Fair enough. And on that, Rod, do you have anything you want to say on this topic before we go to a commercial?
I mean, these people work for the people, so people will get what they want eventually. So we just got to keep fighting.
Fair enough. Fair enough. Keep the fight alive. And on that, we're going to roll into a commercial and keep the fight alive.